Imagine writing like a flawless recipe. You measure out the exact grams of flour, the precise temperature for the oven, the perfect resting time for the dough.
Right, an absolute masterpiece of culinary science.
Exactly. On paper, it's perfect. But
Yeah.
then you hand that pristine recipe over to a commercial kitchen that has, well, absolutely no health inspector, a broken lock on the back door, and a staff that just frequently rotates out without telling anyone.
At that point, the recipe itself doesn't really matter much.
Yeah.
The kitchen is just operating in a state of, logistical anarchy.
Yeah. The structural integrity of the instructions simply cannot survive the actual environmental reality of the floor. And welcome to this deep dive, because our mission today is to explore that exact collision, but on a massive international scale.
Oh, for sure. It's a huge issue.
We are looking at the often chaotic intersection between theoretical law and on-the-ground reality in global trade. And we have this really fascinating stack of sources to guide us through it for you today.
We really do. We're parsing a rather quirky administrative notice from the Surface Transportation Board and then a heavy-hitting 2026 Section 301 investigation document from the U.S. Trade Representative.
Right. Plus Vietnam's 2005 intellectual property law and 3 highly practical on-the-ground enforcement guides. Those include official documents from the UK government and the Rouse legal network.
It is quite the juxtaposition,
Yeah.
like high-level diplomatic theory meeting actual trench warfare pragmatism.
Totally. And the hook for you today is this. We are going to unpack how a rapidly growing global tech hub with comprehensive hypermodern laws clearly written on the books somehow ended up in the crosshairs of a major international trade investigation over fake milk and global cyber lockers. Okay, let's unpack this.
To truly grasp how global trade disputes operate at that macro level, it actually really helps to look at the micromechanics of administrative law first.
Right, the granular stuff.
Exactly. Before we even cross the ocean to look at international intellectual property, we have to understand how rigid administrative rules govern domestic commerce. And that Surface Transportation Board notice you mentioned is like the perfect mechanical example of this.
You mean the Federal Register notice from May 2026? The one outlining a rail exemption for a logistics company called GVSR.
Yeah, that's the one. Just look at the sheer mechanical precision required in that document. The government is granting an exemption for a specific rail transaction, but the parameters are absolute.
Under $5 million, right?
Yes. The transaction must be under $5 million. The exemption becomes effective on an exact date, June 17th, 2026.
Which is, what, precisely 30 days after the notice was formally filed?
Exactly. And the most critical mechanism here is the penalty for inaccuracy. If any information provided in that filing is false or misleading, the exemption is void ab initio.
Meaning it's invalid from the absolute beginning, like it never even existed.
Entirely erased. I mean, the whole mechanism of administrative law relies on that strict compliance. You file a paper, you meet the rigid criteria, and you get the legal protection. If you deviate by even a fraction, the protection vanishes.
Wow.
Global commerce is built on millions of these tiny, precise administrative foundation stones. So take that concept of strict, unforgiving compliance and apply it to Vietnam's framework for intellectual property.
Because when you look at their system on paper, it's engineered with that exact same level of meticulous precision. We're looking specifically at Vietnam's IP law, law number 50 from 2005.
Right. Vietnam is a World Trade Organization member. That means they're fully compliant with TRIPS, which is the International Agreement on Trade-Related Aspects of Intellectual Property Rights.
And their legal framework isn't just a broad set of guidelines either.
No, not at all. It's incredibly comprehensive. They offer standard 10-year protections for trademarks and 20-year protections for patents. But they go much deeper, offering specific legal frameworks for plant varieties, layout designs of semiconductor integrated circuits, and even sound marks.
The level of detail required to access those protections is striking. I was looking at the Vietnamese trademark registration guide, and they require exact physical dimensions for a trademark application.
Oh yeah, you can't just submit a digital file.
Right. A business can't just send over a JPEG of their logo. You literally have to submit 5 physical samples, and each one must fit perfectly within an 80 by 80 millimeter square.
Simultaneously cannot be smaller than 8 millimeters.
Exactly. It's so specific, and the rules governing distinctiveness are just as rigid. The administrative guide specifically notes the mechanism for rejecting generic trademarks.
Right, like if you try to register a descriptive name.
Yeah, for example, attempting to trademark the phrase beautiful hair for a hair salon. The administrative body will automatically reject it because the phrase merely describes the service being offered.
It lacks the distinctiveness required for an intellectual property monopoly. And all of this is governed by the first-to-file rule.
Oh, this part is fascinating. If two independent engineers invent the exact same piece of technology, or two designers create an identical logo, the legal rights do not go to the person who can prove they created it first.
Nope. The rights belong entirely to the person who gets their paperwork date-stamped at the administrative office first.
It operates entirely like calling shotgun on a road trip. It literally does not matter if you were the one who built the car, bought the gas, and meticulously planned the route. The only mechanism that matters is who yelled shotgun first.
That's a great way to put it. The first-to-file system creates this deliberate race to the administrative finish line. The underlying logic is that it forces businesses to create a clear, undeniable paper trail.
It removes the ambiguity.
Exactly. The administrative office doesn't have to launch a lengthy investigation into who had the idea first. They just look at the timestamp on the paperwork.
And here's my pushback. If these laws are so meticulously crafted down to the 80-millimeter boundaries of a logo and the unforgiving first-to-file timestamp, why are foreign governments like the UK officially advising their businesses operating in Vietnam to physically lock up their manufacturing molds at night?
Yes.
The on-the-ground guides are actually warning businesses to constantly check their own factories for illegal overrun.
Right, the classic third shift problem.
Exactly. You hire a factory to produce, say, 10,000 genuine pairs of sneakers. They run the day shift, fulfill your contract perfectly, but then they keep the machines running for a secret third shift overnight.
Manufacturing an extra 5,000 units using your exact physical molds and materials.
And then they just sell them out the back door. So if the administrative paperwork is so flawless, why is the factory floor so treacherous?
This raises an important question. How does a nation maintain such a robust, precise legal framework on paper, while simultaneously struggling with such a porous, exploitable reality on the ground?
And that structural failure brings us to the real bombshell in our source stack today. On May 29, 2026, the Office of the United States Trade Representative, the USTR, initiated a formal Section 301 investigation into Vietnam.
And to understand the gravity of that, we really have to look at how a Section 301 investigation actually functions. This is not a standard diplomatic memo or a polite request for policy review.
No, it's pretty serious.
A Section 301 is effectively the economic nuclear option for the United States. It's a statutory mechanism that allows the U.S. president to unilaterally impose sweeping tariffs or trade sanctions on a foreign nation.
Wow.
Yeah. The U.S. utilizes this tool when it determines that a foreign country is denying adequate and effective protection of intellectual property rights, to the point where it actively burdens or restricts U.S. commerce. Initiating a 301 usually means years of bilateral negotiations have failed to yield physical results.
And just to impartially report on the contents of this Federal Register notice, the language the U.S. government uses is incredibly stark. We aren't taking sides here, just reporting what the document says, and the trade representative actually identified Vietnam as a priority foreign country.
Yeah, that's a very specific, heavy designation.
The core claim from the USTR is that Vietnam has demonstrated a persistent failure to resolve long-standing IP concerns, despite years of direct engagement stretching back to 2020.
And the specific allegations detailed in the report really expose that massive gap between the law and the enforcement of that law.
Like the piracy stuff.
Exactly.
Yeah.
For instance, the USTR report identifies Vietnam as a premier global hub for online piracy. And the mechanism here isn't just like a single person sharing files from a laptop. We are talking about massive, locally operated cyber lockers.
So server farms, basically.
Yes. Sophisticated server farms, offering sleek English-language interfaces that distribute vast libraries of pirated movies and television shows to a global audience. And they're generating massive ad revenue in the process.
The report states Vietnam currently ranks 8th in the entire world for the piracy of mobile video games. But it isn't just digital media slipping through the cracks.
No, the physical counterfeiting is huge.
The investigation details a sprawling physical counterfeiting network. And we aren't just talking about the classic fake designer handbag sold at a street market. The USTR specifically highlights the explosion of fraudulent listings on major e-commerce platforms.
And through direct-to-consumer live streams. those pose severe health and safety risks.
Yeah.
Because the mechanism of live stream selling has accelerated this dramatically.
Mm.
An influencer can hold up a product, 1,000 viewers click a link, and the inventory is sold and shipped before a regulatory body even knows the broadcast happened.
And the detail in the source that really stands out that is honestly terrifying is the counterfeit milk, fake infant formula, counterfeit food and health supplements.
It's extremely dangerous.
We have moved so far beyond lost corporate profits here. The enforcement gap means dangerous, unregulated chemical substances are being ingested by consumers who genuinely believe they are purchasing a legitimate health-regulated product.
The stakes become entirely physical. Now, if you look at the timeline, the sources point to a very specific structural catalyst for why this crisis peaked in 2026, ultimately prompting the USTR investigation.
When?
Well, in 2025, the Vietnamese government underwent a massive internal bureaucratic reorganization.
Oh, and if we think about how large bureaucracies function, a shuffle of that magnitude almost guarantees chaos.
Completely.
If you merge two disparate departments, say, combining a border anti-smuggling unit with a domestic market surveillance unit, and you suddenly have overlapping jurisdictions, the paperwork flow breaks down.
The officers on the ground no longer know whose desk a counterfeiting claim is supposed to sit on.
Right.
The stakeholders cited in the USTR report confirm exactly that. The 2025 transition created colossal operational gaps in the administrative net, and the counterfeit sellers and cyberlocker operators immediately identified and exploited those gaps.
They took advantage of the confusion.
Absolutely. The resulting data is staggering. According to the investigation, in 2025 alone, there was a 50% drop in the number of enforcement violations successfully processed by Vietnamese authorities compared to the previous year.
Wait, really? A 50% drop in 1 year?
Just from the reshuffle.
Okay, here's where it gets really interesting. If Vietnam has stringent criminal laws on the books laws that, according to the Rouse legal guide, allow for up to 30 years in prison for individuals and up to 5 billion dong in fines for corporate infringers, why are massive cyber lockers continuing to operate openly?
It's a great question.
If the penalties are that severe, why does an administrative reshuffle cause a 50% drop in enforcement? Are the criminal courts just not functioning as a deterrent?
Having a severe penalty available in the criminal code is entirely different from the logistical reality of successfully applying it. To understand why those cyberlockers and counterfeiters operate so brazenly, we have to look at the mechanical framework of enforcement in Vietnam. The criminal system is actually not the primary weapon used by intellectual property holders.
Okay, that makes sense based on the guides. The UK Government Guide and the Rouse Intellectual Property Guide outline what they call the enforcement matrix.
Right.
Because in many Western jurisdictions, if a competitor steals your intellectual property, the immediate instinct is to file a lawsuit and drag them into civil court. But both of these on-the-ground guides explicitly state that in Vietnam, the civil route is largely avoided.
Yeah, there are a few layers to why the courts are bypassed. First, there is a deep-seated cultural preference to avoid adversarial court battles if possible. They strongly favor mediation or administrative intervention. Second, there is a recognized lack of specialized intellectual property training among the local judges. That makes complex patent or digital piracy cases incredibly difficult to litigate reliably.
That would definitely be a bottleneck.
And third, the financial mechanics of the civil system are broken. Even if you win a civil case, if you cannot explicitly prove your exact, calculable financial losses, which is incredibly difficult when dealing with untrackable cash sale counterfeits, the civil court legally caps the damages you can be awarded at 500 million Vietnamese dong.
And doing the conversion based on the Rouse Guide, 500 million dong is roughly $21,600 US.
Exactly.
If a multinational corporation spends $100,000 on specialized legal fees and private investigators to shut down a massive counterfeiting syndicate, a maximum legal payout of 21 grand isn't a deterrent for the counterfeiters. And it certainly doesn't cover the brand's legal costs.
Not even close. And as for those 30-year sentences in the criminal route, the USTR report notes that even when criminal prosecutions do successfully make it through the system, the judges have recently defaulted to handing out mere suspended sentences and nominal financial penalties.
So the threat of prison is on the books, but it isn't materializing in the courtroom.
Exactly.
So if the civil courts are financially capped and the criminal courts are handing out suspended sentences, how is a brand supposed to protect its patents or trademarks?
Well, the primary battlefield, according to the enforcement guides, is strictly administrative. Intellectual property holders rely almost entirely on two main government agencies, the Market Management Bureau, known as the MMB, and the Economic Police, or EP.
The breakdown seems to be based on severity, right? The MMB handles the baseline
Yeah,
cases.
exactly.
They conduct raids on small retail shops, physical markets, or distributors selling obvious counterfeit goods.
Yeah, brands use the MMB for quick, ground-level market sweeps. It's a faster, cheaper process. But if the infringement is highly complex, involves massive organized networks, or deals with dangerous goods like the counterfeit milk or ingestible supplements we discussed, the economic police take jurisdiction.
To put that administrative system in perspective, it sounds less like taking a classmate to a full-blown civil trial with a judge and a jury, and much more like getting the school principal to come down to the hallway.
Right.
They confirm a backpack is stolen, confiscate the bag, and just hand out a detention.
And to take that principal analogy further, the administrative authorities don't always have to wait for the student to formally complain. These agencies have the power to conduct what are called ex officio raids.
What does that mean in practice?
They act as the eyes and ears of the intellectual property holders. If officers from the Market Management Bureau are conducting a routine sweep of a warehouse and spot suspected fake sneakers, they have the legal authority to seize those goods on their own initiative and subsequently contact the brand to verify the counterfeit status.
Oh, wow. But the sources reveal a massive loophole in that exact ex officio power, specifically at the borders.
Yes, the customs issue.
The USTR investigation points a glaring spotlight at the Vietnamese Department of Customs. Back in 2022, amendments to the IP law gave customs officials the explicit authority to proactively suspend customs procedures if they suspected counterfeit goods were crossing the border.
But the U.S. claims customs officials rarely, if ever, actually exercise that authority.
Right. And even more critically, the law does not grant customs the power to act on in-transit goods.
The in-transit loophole is massive. It means that if a shipping container full of counterfeit video game consoles arrives in a Vietnamese port, but the paperwork says the final destination is a neighboring country, the goods are just passing through.
So they can't touch them.
Right. They are legally invisible to Vietnamese customs enforcement. The container moves through the port untouched.
And since the government's administrative net is so porous, it puts the onus entirely on the brands to police the market themselves. The Rouse Guide actually outlines a fascinating first step that brands utilize before they even call the Market Management Bureau. They send a warning letter.
The warning letter is a crucial mechanism for self-protection and cultural navigation.
What's really fascinating is that it isn't just an aggressive, threatening cease and desist letter drafted by a corporate lawyer like you'd see here. The guide notes that in local practice, sending a warning letter is considered a necessary initial attempt to educate the infringer.
Yes.
The posture is essentially, we assume you might not realize you're infringing on our registered patent, so here is your formal education on the matter.
In many business cultures, providing an opportunity for the offending party to correct their behavior without public embarrassment to save face prevents the situation from escalating into entrenched, spiteful litigation.
That makes a lot of sense.
But mechanically, it also serves to build an undeniable paper trail of good faith. If the infringer ignores the educational warning letter and continues to sell the fake goods, it serves as hard evidence for the brand.
Oh, I see.
When they finally do call the Market Management Bureau, they can prove they attempted to resolve the issue amicably before demanding an administrative raid.
That's really smart.
If we connect this to the bigger picture, you can see precisely why this physical administrative system is buckling under the weight of the digital age. Administrative market sweeps and physical warning letters work perfectly for seizing fake jackets from a tangible market stall in Ho Chi Minh City.
Yeah.
But how does the Market Management Bureau conduct a physical sweep of a globally distributed cyber locker hosted on an encrypted cloud server?
The digital landscape turns the hurricane into a Category 5. The Rouse Guide does mention Decree 15, issued in 2020, which specifically attempts to address online IP violations. It gives authorities the power to hit digital platforms with fines of up to 70 million dong and force the removal of infringing content.
But the enforcement gap immediately neutralizes that decree.
How so?
The legal guide explicitly states that it remains completely unclear how those administrative sanctions can practically be enforced against foreign entities that provide cross-border digital services to Vietnamese users. The 2018 cybersecurity law exists on paper. Decree 15 exists on paper, but the digital borders are far too fluid for a purely administrative, physical enforcement mechanism to trap.
And the operators of those massive English language cyber lockers understand the mechanics of the bureaucracy perfectly. They know that historically, the jurisdictional follow through just hasn't been there.
Exactly.
So, what does this all mean? Let's bring all these sources together for you listening. What we are observing in Vietnam is a profound structural paradox. On one side, you have a booming, highly modern economic powerhouse, deeply integrated into global trade agreements. They possess intellectual property laws so meticulous that they dictate the exact millimeter dimensions of a submitted trademark logo.
But on the opposing side, you have a bureaucratic reality where enforcement is an incredible bottleneck. The civil courts are financially capped and culturally bypassed. Their criminal penalties, while severe in the legal code, frequently dissolve into suspended sentences.
Right.
That shifts the entire burden of global IP protection onto administrative agencies.
And when a single internal government shuffle occurs, like that massive bureaucratic reorganization in 2025, that administrative net fracture,
Yeah, it breaks down.
the overlapping jurisdictions and confused reporting lines resulted in a 50% drop in enforcement, allowing everything from counterfeit infant formula to global video game piracy to flood the market, ultimately triggering a unilateral Section 301 trade investigation by the United States.
And why does an administrative bottleneck in one nation matter to you? Because the gap between legal theory and physical enforcement inevitably ripples outward. If you are an engineer or a creator, your intellectual property might be flawlessly protected by a filed patent. But if a factory can easily run a secret third shift and the civil damages for catching them are capped at $21,000, your entire business model is at risk.
Absolutely.
If you manage a supply chain, you cannot rely on customs. You have to actively police your own borders.
And if you are a consumer buying health supplements or milk powder from an e-commerce live stream, that bureaucratic enforcement gap suddenly transforms into a direct threat to your physical health. The pristine recipe doesn't matter if the kitchen is compromised.
The law is ultimately only as protective as the logistical enforcement mechanism backing it up.
Which leaves us with a final thought for you to mull over. We've traced how a single nation's internal administrative shuffle in 2025 triggered a 50% drop in enforcement, creating a temporary safe haven for global cyber lockers and massive digital piracy. As our global economy becomes increasingly borderless, frictionless, and digital, are we moving toward a reality where digital intellectual property is ultimately only as secure as the weakest link in the global administrative chain? Can borderless digital IP ever truly be policed by physical national borders?
It is the ultimate stress test for global commerce.
The blueprint of the law might be architecturally perfect, but when the hurricane of global trade hits, you have to hope someone on the ground actually knows how to close the windows. Thanks for joining us on this deep dive. We'll catch you next time.